তো দেখো লিস্টে দেখবে দেখবে I may private to mention original side matter, my lord. It was adjourned for 2 weeks, but thereafter did not appear in the list, my lord. But kindly place it at the list, in the list, so that your lord.
What is this issue?
The central excise matter, my lord.
2025 matter.
Yes, my lord. 25.
With my lord's leave, my lord, these are two appeals under section 260A arising out of the same proceeding. My lord, in one has heard my lord substantially. This was that appeal, my lord would recall, where advocates were changed before the tribunal, my lord, directed to file an affidavit to such
You
extent.
give, let us see.
My lord. And my lord, with my lord's,
I've got only 8 more days to go.
my lord, with my lord's leave, item number 4. It has been, my lord, brought to my knowledge that it is being listed for some time, and my lords have at least on two occasions taken up this matter. I appear for the advocate on record. I am the advocate on record, my lord. I am, my lord, unable to get in touch with the petitioner, my lord. As such, my lord, I express my intention to retire from the brief.
Item 4, that is ITAT 24 of 20.
My lord, my lord.
What is the issue?
My lord, that it was an appeal filed under 260A. But my lord,
Can you wait for 10-15 minutes?
Absolutely.
Let the matter reach. We'll see what can be done.
With the Lordship permission, may I ask for an indulgence, Lordship? Item number 11, there is an intra-court appeal. I'm an outstation counsel, Lordship. I have been informed by the advocate on record that Lordship are going to take appellate side matters at 12 o'clock. So Lordship can kindly accommodate me.
And who will appear for the respondent?
So Prithu Dudoria.
Assistant Commissioner of Income Tax.
Prithu Dudoria, sir.
Where is he?
He's coming.
All right. Please wait. We'll take it up.
Lordship, pray for your Lordship's indulgence to mention an income tax appeal of an individual assessee. Your Lordship, it was admitted by your Lordship's bench. Thereafter, paper book has been filed. But unfortunately, on latches on our part also, it was not mentioned. Your Lordship, it has not come up. Your Lordship,
Let us see what can
kindly directs your Lordship to list this
Let me
matter.
see.
Lordship, may I be permitted to mention, this was mentioned previously as well, two ITAT appeals
Gratefully.
in the admission stage, which was supposed to come up in September's monthly list, but the CIS is showing as November's monthly list.
to advance the date.
We had mentioned
give the number,
immediately.
we'll verify.
Very
We'll call for the file. We'll see what is the file noting and then
very much.
please call.
Original side daily list, item number 1 to be mentioned.
Lord, this is my matter, my lord. It's an appeal.
Why is it coming under?
Well, it's short point. The only reason is the tribunal is insisting on compliance of the order. Now, the short point is tribunal had passed an order of refund. Thereafter, that was upheld by my lord's bench. Consequently, refund was given to them. Thereafter, they filed an application appeal before the commissioner appeals, saying that interest has not been given. Now, while doing that, they also filed, while that was going on, they filed a miscellaneous application before the tribunal, and tribunal passes an order of refunds from the first day with 9% interest.
But what did the commissioner do on the application for interest? He is granted interest.
No, commissioner has not granted interest.
No interest, not even a single line on interest.
This is what I'm saying.
Commissioner's order.
Yes.
The commissioner's order came in.
We'll hear out the appeal.
My lord.
My lords, may kindly hear out the appeal subject to my lords. I'll just kind of indicate one technical objection, my lords. This is an appeal against an order passed in order 41, rule 41 of the CSTAT procedure rules, my lords. My lords, I am supported by two judgments of two different high courts, my lords. One in an exactly identical fact situation where the honorable tribunal in an application under rule 41 of the CSTAT procedure rules had granted for payment of interest. Against that, the revenue preferred an appeal before the honorable Karnataka High Court under the Customs Act, section 130, my lords. And section 130 is parameteria insofar as excise is concerned. It is parameteria with section 35G of the Central Excise Act. Now, interestingly, what the honorable Karnataka High Court has said is that under section 130, what can be appealed is an order passed by the tribunal in appeal under section 129B. And here also, my lords, insofar as the statutory appeal under section 35G is concerned, that has already been disposed of, my lords. And it is only for the implementation of the CSTAT's order that we had filed an application for refund of interest, because that was not granted by the commissioner. Now, my lords, in that factual matrix, my lords, My humble submission is that this appeal itself is not maintainable, my lords. Two honorable judgments, two honorable courts, my lords, Bombay High Court and the Honorable Karnataka High Court has clearly held that appeal in such cases not maintainable, statutory appeal. And what the Karnataka High Court traveled up to the Supreme Court has dismissed revenues appeal.
So that will be the first question to be decided.
Yes, my lords. So, which is
That
why, my lords, I mean,
But in the meantime, if you insist upon the implementation, the appeal becomes infructuous.
my lords, so which is why I'm kind of besieging my lords. If my lords can decide on the maintainability today and thereafter, my
Here
lords.
there was no order.
Not today. We can't do it today. Probably on 8th or 9th, we'll try to argue on the maintainability. See, otherwise, even assuming we accept your submission, he can't be left remediless.
He can prefer a writ petition.
That is true.
Yes,
So
yes, my lords.
therefore, some remedy has to be there.
Yes, yes, my lords. And in fact, my lords, in one of the matters, the revenue has preferred a writ petition against such an order.
That's on a different fact situation, because if my lord sees the section is
You
very
give
clear.
those two decisions.
Yes, my lords. I'm carrying that.
Here the order was only for refund. Refund was processed within 3 months. Thereafter, on the point of interest, there was a deficiency. The payment, the refund was made within 3 months. Thereafter, they filed an appeal against that order before the Commissioner Appeals. While the Commissioner Appeals was on, he goes and files a miscellaneous application, says you have not passed an order of interest, therefore give an order of interest. He gives an
Kindly
order of
takes
interest.
page 12 of that compilation, my
Yes,
lords.
we saw that.
Page 12, my lords. Exactly identical fact situation, my lords.
All right. This appeal has been filed by the Revenue under Section 35 capital G of the Central Excise Act 1944. Certain substantial questions of law have been suggested by the Revenue. The learned advocate appearing for the respondent assessee raises a preliminary objection as regards the maintainability of the appeal by contending that the order impugned in this appeal has been passed by the learned tribunal in terms of Rule 41 of the CEST Act within bracket Procedure Rules 1982, and as against such order, an appeal is not maintainable under Section 35G of the Act. In support of his contention, reliance has been placed on the decision of the High Court of Karnataka in the case of Commissioner of Customs Bangalore versus Toyota Kirloskar Auto Parts Private Limited, 2013 295 ELT 680 within bracket Karnataka. It is submitted that in the said decision it was held on identical fact situation that an appeal under Section 35 capital G was not maintainable. The appeal filed by the Revenue before the Honorable Supreme Court has been dismissed. As reported in 2013 within bracket 297 ELT A capital A 149 within bracket SC. Therefore, at the outset, because the preliminary objection raised by the learned advocate appearing for the respondent assessee has to be considered, and if the and in the case the objection is sustained, then the appeal has to be held to be not maintainable. On the other hand, if the preliminary objection is decided against the respondent assessee, the court has to consider the substantial questions of law raised in this appeal by the Revenue. Therefore, the appeal has to be heard on merits and decided. It appears that since no order of stay has been granted by this court, the learned tribunal has passed a direction on 24th July 2025, adjourning the matter to 7th August 2025, with a direction to the Revenue to either obtain a stay order from this court or comply with the order dated 4th July 2025. In the light of what has been noted in the preceding paragraphs, the appeal requires to be heard, and it is not feasible to do so today. Therefore, let the appeal be listed On 9th September 2025. In the meantime, if the revenue is required to comply with the direction issued by the learned tribunal in its order dated 4th July 2025, the appeal itself will become infructuous. Appeal filed with the revenue will become infructuous. Therefore, the order and direction issued by the learned tribunal in its order dated 4th July 2025 shall remain stayed. List the matter for here on 9th September for hearing the preliminary objection.
My lord, only one thing. There's in ground number 14 and question number 5, instead of 35B of Central Excise Act, 129A of Customs Act has come in, my lord.
It appears that there is some inadvertent mistakes has occurred in the grounds raised by the appellant revenue. Leave is granted to the learned advocate for the appellant to correct those defects.
Both in the memorandum of appeal and stay application.
Both in the memorandum of appeal and the stay application.
Grateful, my
lord. Just 1 minute. I'm taking your lordship's 1 minute. Mr. Dastur, former additional solicitor general and senior advocate, passed away just an hour ago. So, my lord, we would beseech your lordship, my lord, the resolution is being taken right now. We will.
Yemen Dastur.
Yemen Dastur.
Yes.
So, my lord, we are all leaving for the hospital right now. He is at Medica.
But he was in the Supreme Court practicing for a long time.
Mr. Dastur, former additional solicitor general and senior advocate. YJ Dastur. YJ Dastur.
YJ Dastur.
Yes.
From our
tall figure, my lord.
My lord,
Practice in the criminal side.
criminal side.
I think I am not.
No, your lordship may not have.
My lord hasn't seen it.
Yes.
Prior to Mr. Ashok Chakraborty, he was the additional solicitor.
Yes.
My lord, Mr. Dastur has appeared before your lordship when your lordship was sitting in court number 16. Your lordship kindly recollects a matter of preventive detention matter. Mr. Dastur addressed your lordship extensively in that matter. In court number 16.
Because we were dealing with habeas corpus petitions at that time.
Yes.
In fact, Mr. Dastur and I, as well as Mr. Dey,
Show the photograph in the.
Yes. Let me see, my lord, if I have got.
Not very active on social media.
I think so, my lord.
No, no.
I think so.
Not in the social.
But that's a very young picture.
Yeah.
Yes, I remember now.
So, my lord, we are in the process of taking resolution.
Only one request. There is a learned advocate from which place, sir? From Bombay has come.
Yes, my lord.
Only one matter.
Yes.
Prithudoria is there for the response. He is not there. He is going.
So, my lord, we are taking your lordship's
Yes,
time.
definitely. What is? Please call that Kesoram Industries item 11.
Item number 2 is an expeditious hearing matter.
My lord, this can be disposed of the application. I will very humbly submit to your lordship, and it's a matter which can be disposed of by lordship by one hearing itself. I tell your lordship what has happened.
Then we will adjourn it with the understanding, or it will remain in the list with the understanding that you argue the appeal itself.
Yes.
Otherwise, you dispose of it. Go.
My problem is Monday. Can I please
Tuesday.
come back on Tuesday?
Tuesday. List this up, item 2 immediately after fresh miscellaneous application. Wednesday.
Yes. So great.
Item 11.
11.
नाम दिए देबो
And anybody from the Bar Library Club? You are from Bar?
no, I am from the Intra Society.
No, today there is a book release function.
Yes, in the evening.
In the evening, auditorium.
Yes, my lord.
I don't know what. And there is another function in the auditorium by the Industrial Tribunal Lawyers. Where is Justice Ganguly? Everybody has been invited. Delay can be condoned 44 days.
44 days.
Sir, condoned, sir. Satisfied with the reason, condoned. What is this
Lordship,
intra?
much grateful for the indulgence given to me today, Lordship. First is an intra-court appeal arising from the order of the single judge, Lordship, wherein I challenge the notice under section 148 of the Income Tax Act and the consequential proceeding. I raised, Lordship, as many as 5 grounds on jurisdictional as well as on natural justice violation and issue of SOP. The first ground, Your Lordship, was under section 151A. The jurisdictional assessing officer, Your Lordship, are aware that has no jurisdiction to issue the notice under section 148. It has to be issued by the faceless. Lordship, this issue, Lordship, is now covered by several judgments of several high courts, and even SLP has been dismissed.
But then the learned judge says you didn't challenge the 148 notice.
That is incorrect, Lordship. I'll find out. I'll point out, Your Lordship.
Show the
Lordship.
prayer and the writ petition.
Lordship.
Where is the writ petition?
Lordship. Writ petition, Your Lordship, is at page number.
Prayer is that page 85.
Lordship. Yes.
Set aside the impugned notice. Oh.
My ground is also there, Your Lordship.
So you challenge the notice as well as the order,
Lordship,
and the assessment order.
Lordship.
And what is the ground of
And even before the assessing officer, I had raised this objection twice. But the learned assessing officer says that because the SLP has been admitted from the Telangana High Court judgment, even that, Lordship, with all say it's incorrect because SLP has not been admitted, only notice has been issued. Lordship, and the recent development is that 2 SLPs, Lordship, has been dismissed by the Supreme Court, arising one from Telangana and one from Bombay.
What ground you challenge 148 notice?
Lordship, there were 3 jurisdictional grounds. Number 1, the faceless assessing officer only has the jurisdiction to issue, not the jurisdiction.
In that case, we have admitted.
Yes, my lord. No, my lord has passed an order. Done with the.
That Dalmia.
No, post Dalmia, my lord had passed done with the. My lord has held that. This is mine. You give it to me. Yeah, this. Arache Dhanvriti.
What does it say?
So the appeal has been kept pending.
Yes, my lord. My lord had extensively gone into the judgment of the Delhi High Court.
And we rejected the prayer for stay.
Yes.
But your friend will not be aware.
Kindly see the compilation now, Your Lordship. The recent development, Your Lordship, 2 SLPs have been dismissed by the Supreme Court, revenues SLP, even on merits, Your Lordship. Kindly see page number 1, Your Lordship, Justice Paradiwala's judgment. Para 2, Your Lordship. Even otherwise, we see no reason to interfere with the impugned order passed by the High Court.
What is the order?
Your Lordship, the impugned order of the High Court is at page 2, Your Lordship. It follows Hexaware of Bombay High Court.
In fact, we considered all that.
Yes.
And this is very recent.
No.
18th August 25. In the second order, Your Lordship, from Telangana,
Sir, our order is dated 25th of February 2025.
But there is 18th August 25. Just 10 days back, Your Lordship.
The High Court order is 12th of August 2024.
Lordship.
We considered Hexaware and we have passed this order. If you want, you go through this
I have
order.
given it to you.
Lordship.
And in the meantime, what has happened now? Demand notice has been issued.
Lordship.
Probably we'll grant you an interim order for 2 weeks.
Lordship.
You go through this and come back on the next date.
Lordship.
Whichever is, you see your diary, whichever is convenient, you come back.
Lordship, may I also point out, Lordship, there are 2 other also jurisdictional fatal errors which have not been considered by the single judge, Lordship.
But the problem is, you should have immediately approached the Red Court. You participated in the proceedings.
Lordship.
It resulted in a rejection of your objections.
Lordship.
Then the 142 notice.
I appreciate what is following my Lordship, but Lordship is a jurisdictional error, and not one, Your Lordship. There are 3. There are 2 other jurisdictional grounds. The approval, Your Lordship, is unsigned.
Approval is unsigned.
Lordship. Kindly see, Your Lordship.
And what is the finding of the single bench on that?
Lordship, the 2 other jurisdictional ground has not been adjudicated by the single. In the third one, Your Lordship, there is an amendment in section 148 with effect from 1st of April 23 that I should be given minimum 3 months time to file the return of income. The one 148 notice which has been issued, it's also in violation of the amended provision,
You
Lordship.
filed it.
And just Chief Justice Sagla,
They have
Lordship,
done everything and
1954.
then they're questioning that.
No, Lordship, I'll point out from the writ court has not adjudicated
The
this.
satisfaction has not been signed. It's a very serious error.
No, they have filed it. They filed the return. They have,
Satisfaction for
that
the-
has also been given.
where
The satisfaction has been given. He is not raising
No,
that point.
I'm
on
saying the satisfaction is unsigned.
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 That issue has not been adjudicated by the learned bench. All right. This intra-court appeal by the writ petitioner is directed against the order dated 15th May 2025 in WPO 340/2025. In the said writ petition, the petitioner has sought for quashing the notice issued under section 148 dated 12/4/2023, the assessment order dated 28/3/2025 passed under section 147 of the Act of the Income 148 of the Income Tax Act. Assessment order dated 28/3/2025 passed under section 147 of the Act, and the notice of demand dated 28/3/2025 under section 156 of the Act, and the show cause notice dated 29/3/2025 under section 274 read with 271 AAC all capitals within bracket 1 of the Act. The learned single bench, the petitioner has, the appellant writ petitioner has primarily raised 3 grounds which according to the learned advocate appearing for the appellant are jurisdictional issues.
Satisfaction letter.
The first of which is that the first issue, according to the learned advocate for the appellant, is covered by the decision of the High Court of Bombay in the case of Prakash Panduranga Patil versus Income Tax Officer Ward 5, HON'BLE and others, WP number 10749 of 2024 dated 12th August 2024, which was decided in favor of the said assessee, and the special leave petition filed against the said order in SLP in special leave petition within bracket civil diary number 39689 of 2025 was dismissed by the Honorable Supreme Court by order dated 18/8/2025. Further, the learned advocate submitted that in the that identical question arose for consideration before the Telangana High Court. Before the High Court for the state of Telangana at Hyderabad in WP number 23573 of 2024, which was decided in favor of the assessee, and the special leave petition filed by the revenue in special leave petition civil diary numbers 33956 of 2025 was dismissed by the Honorable Supreme Court by order dated 16/7/2025. Furthermore, it is submitted that the approval which is required to be granted by the Principal Commissioner of Income Tax is an unsigned document. Other jurisdictional grounds have also been canvassed. The learned senior advocate appearing for the respondent department placed reliance on the order passed by this court in the case of Dhanvantri Como Trade Private Limited and another versus Income Tax Officer Ward number 2 within bracket 1 Calcutta and others in MAT number 1350 of 2024 dated 25/2/2025, wherein the prayer for stay was rejected and but the appeal was kept pending for the reasons assigned in the said order. Thus, the effect of the recent decision of the Honorable Supreme Court affirming the orders passed by the Honorable by the High Court of Bombay and the High Court for the state of Telangana have to be considered in this appeal. Furthermore, it is seen from the impugned order, the learned single bench was of the view that the assessment order alone has been challenged. and that there is no explanation in the writ petition as to what prevented the petitioner from challenging the notice under section 148 previously. This issue also requires to be considered as to whether the appellant, having participated in the proceedings before the assessing officer, could be is entitled to question the assessment order passed under section 147 of the Act when a statutory appellate remedy has been provided. Therefore, to consider all these grounds, let the appeal be listed for admission, listed on 22nd September.
10th or 11th, Your Lordship.
No. 22nd September 2025. And there will be an order of
It can be on 24th. Monday, Tuesday, Lordship becomes very difficult from Bombay.
24th September. And the
25th, I think, is our last day before annual vacation. If my lord keeps it after vacation, then
or we'll fix it in November.
yes.
Appeal be listed on 12th of November 2025, and the impugned and the assessment order impugned in the writ petition and the notice of demand and the subsequent show cause notice issued to the appellant writ petitioner shall remain stayed till 21/11/2025. List the matter on what date I gave? 12th November.
13th November.
13th
13th
November.
November. One more, Your Lordship. The SLP has been dismissed on merits, Your Lordship. Mention that, Your Lordship, in the opening paragraph.
That has to be argued, no? They will say whether the doctrine of merger, etc.
Much obliged, Your Lordship, for the indulgence also granted.
You are Mr. Devendra Jain.
Lordship.
You are regularly coming to Calcutta?
Lordship.
What to do now? The judgment will pronounce. The judgment will pronounce. You can call them. So we'll go and come back. In the meantime, if they come, we'll be both waiting in the chamber.
Okay, good. সুমন্ত হ্যাঁ বলেছে সায়ক ফোন করলো সায়ক তো মানে এটা কি করে সায়ককে ছেড়ে দেন এখানে অন্য বাবা ঢুকে গেছে তাহলে ঢোকাতে পারিনি ঢোকাতে পারিনি
Appellate side supplementary list under the heading for judgment, serial number 1.
But I pay for the appellate, my lord.
Yes, sir. Yes.
Not sure I'm for the respondency.
Because the judgment got ready, so we thought we'll
No,
deliberate.
deeply
Instead
obliged. Deeply obliged.
instead of postponing it. For all the above reasons, the appeal is allowed. The order passed by the learned single bench is set aside with the following directions. The compensation which was determined by the competent authority in the order dated 22/5/2023, which was impugned in the writ petition, is held to be a determination of compensation by the competent authority in the first instance in terms of section 10(1) of the 1962 Act. Number 2, in the absence of an agreement between IOCL and the appellant with regard to the rate of compensation, and in the absence of any record to show that the appellant had unequivocally accepted the sum of rupees 450, it has to be held that the amount of rupees 450 which was computed, determined and paid to the appellant, being a total sum of 42,12,245, is a compensation determined at the first instance, and the appellant is entitled to file an application before the concerned district judge for enhancement. 3. Having held that the compensation which was determined and computed by the competent authority in the order impugned in the writ petition is a compensation determined at the first instance, the appellant are entitled to file an application before the concerned district judge under section 10 within bracket 2 for enhancement of the said compensation. Number 4. IOCL is directed to pay the compensation as computed by the competent authority in the order dated 22/5/2023, impugned in the writ petition, within the period of 30 days from the date of receipt of the server copy of this order, and the appellant is at liberty to file an application before the concerned district judge for enhancement within the period of 3 months from the date on which the amount as ordered by the competent authority is paid in full to the appellant. The concerned district judge shall entertain the application and decide the same on merits and in accordance with law. In the 5. In the light of the facts recorded in the Panchanama dated 22/5/2023, the respondent IOCL stopped from raising any argument alleging that the appellant had violated the restrictions contained under section 9 of the 1962 Act, as it was well within the knowledge of the IOCL that the land was put to use for fishery purpose. In the next para. In the operative portion of the judgment and order, we have held that IOCL were not entitled to object to the jurisdiction of the competent authority in the light of the order passed in the earlier writ petition in WPA 198/95 of 2021, and it would tantamount to waiver. However, in the light of the conclusion arrived at by us, holding that the determination of the compensation by the competent authority in the order impugned to the writ petition is a compensation determined in terms of section 10(1), 10 subsection 1, the said finding has become academic. The appeal is allowed with the above direction.
I'm seeking a formal stay, to the extent of that payment portion. Kindly, my lord, record that your lordship is.
I have never done so. I have got 8 more days to go. Please leave me alone.
But one thing, but may I only inquire from a lordship's lord that the lordship has directed the point number 3 that the compensation is to be paid by IOC That is the compensation for the remaining portion of 974 days, which was not determined by the, I was not paid by the IC. Am I, my lord, correct in my understanding of your lordship's order?
Mr. Kundu, please go through the judgment.
Very well.
We have held that the competent authority the order has computed it's a first instance. The
Yes.
learned single bench said it's a determination already made. So
Oh.
apart from that 42 lakhs, you can seek for enhancement. This amount will be paid. This also you can seek for enhancement. Go through the judgments.
Very well.
No, if you are not satisfied, then you
No,
file an appeal. You
No,
also.
no, no, I'm not saying, I'm just because since your
That's
lordship.
our understanding. We can't be more.
No, since
intelligent
your
than what
lordship
we
has
are.
read the entire judgment, so naturally let me go through the, but I'm deeply obliged to your lordship, but for writing and passing the order before your lordship. Deeply
Yes.
obliged to your lordship.
Deeply obliged, my lord.